This podcast uses AI-generated content. All information is for general purposes only and does not constitute financial, investment, legal, or regulatory advice. Listeners should verify information independently and consult qualified professionals for personalized guidance. Welcome to the Luxembourg Fundcast. Today, we're doing a deep dive into something really central for anyone involved in the Luxembourg financial sector. We're looking at the beneficial ownership regime, often just called the BO regime.
That's right.
And it's seen some, pretty significant changes recently. This isn't just fiddling around the edges, is it? We're talking about a major strategic shift.
Absolutely. It's a real recalibration. What we want to do today is unpack how Luxembourg has responded to a really key European court ruling. It's pivoted towards a system that's, arguably more robust, but also, more targeted. It's a fascinating interplay between needing to fight money laundering, AML, and upholding that fundamental right to privacy.
So our mission today is to understand that balance. We'll look at the legal shifts, the practical steps for you, and the broader strategic picture. And there are three big developments we think you really need to get your head around for those aha moments. First, this whole new approach to accessing the Register of Beneficial Owners, the RBE.
Yeah.
It's now based on legitimate interest.
That's change.
Second, those new administrative fees for late filings. They've ramped them up significantly, making deadlines, financially critical.
Non-negotiable, really.
And third, we'll dig into why identifying the ultimate beneficial owner of the UBO is still, pretty complex. It's definitely more involved than just looking at who owns the shares.
It requires proper analysis.
Exactly.
Yeah.
So by the end of this, you should feel much more confident navigating these changes. Ready to dive in?
Let's do it.
Okay, so where does this story begin? You mentioned a court ruling that really kicked things off across Europe.
That's the starting point, yes. The catalyst was a landmark judgment from the Court of Justice of the European Union, the CJEU, back on November 22nd, 2022. It concerned joint cases, C3720 and C60120. And what the court's Grand Chamber did was invalidate a key part of the 5th EU Anti-Money Laundering Directive, or AMLD5.
Which part specifically?
The provision that allowed basically anyone from the general public to access beneficial ownership information without needing to show any particular reason.
Ah, okay. And why did the court strike that down?
The reasoning was grounded very firmly in fundamental rights. The CJEU found that giving everyone open access like that was a serious interference with the right to privacy and the right to protection of personal data. Mm-hmm. Those rights protected under Articles 7 and 8 of the EU's Charter of Fundamental Rights.
Right.
Now, the court didn't dismiss the goal. Preventing money laundering is obviously crucial, but it decided that general public access wasn't proportionate. It went further than what was strictly necessary to achieve the objective.
And Luxembourg was directly involved in those cases, wasn't it?
Yeah.
The LBR, the Luxembourg Business Registers, was a party.
It was indeed, which meant the impact here was immediate and direct. Public access to the RBE was suspended, temporarily at first.
Creating a bit of a legal headache, I imagine?
Definitely. A moment of real legal uncertainty, not just here, but across Europe. But, it also presented an opportunity for Luxembourg to show its regulatory maturity, its agility.
So how did Luxembourg respond?
Swiftly and decisively, actually. The Luxembourg Parliament moved quickly to address that legal gap left by the CJEU ruling. They passed the law of January 23, 2025. This law amended the original 2019 law that set up the RBE in the first place. And it came into force very quickly on February 1st, 2025.
Okay. And the main goal of this new law?
It was really about alignment, aligning Luxembourg's national rules with how the CJEU interpreted European law. It's about finding that new balance, a legally sound balance between preventing illicit finance and protecting individual privacy, not about reducing transparency overall.
That proactive approach must be seen as a positive, right? Especially for Luxembourg's reputation as a financial center.
I think so, yes. It potentially turns a point of legal challenge into a strategic plus. By quickly adopting a framework that respects the court's decision and fundamental rights, Luxembourg reinforces its image for, legal certainty and stability.
Which is exactly what global asset managers and investors look for, that predictability.
Precisely. It makes the Grand Duchy arguably an even more reliable place to do business.
So the big practical question then, who actually gets access to the RBE now? If it's not the general public anymore, what's the system?
It's now a tiered system. Access is based on necessity, on why someone needs the information. There are essentially 3 tiers.
Okay, let's break those down. Tier 1.
Tier 1 is national authorities. Think judicial authorities like the public prosecutor, the financial intelligence unit here, that's the Cellule de Renseignement Financier, or CRF. Also the financial regulator, the CSSF Commission de Surveillance du Secteur Financier, and the tax authorities, both the ACD and the AEB.
And their access is?
Full and unrestricted. They can see everything, including historical data. And importantly, their searches are confidential. The entity or the UBO isn't notified.
Makes sense for investigations. Okay, Tier 2.
Tier 2 is for obligated professionals. These are the firms and individuals who have AML and counter-terrorist financing duties themselves. So banks, investment firms, insurance companies, auditors, accountants, notaries, lawyers.
The ones who need it for their own due diligence.
Exactly. Their access was suspended for a bit after the ruling, but it's been restored under stricter conditions. They need a verified digital ID from Lux Trust SA and a specific access agreement with the LBR. There's LBR guidance on this.
Right. And then the third tier. This sounds like the biggest change.
It is. Tier 3 is for parties with a legitimate interest. This concept comes directly from the CJEU's reasoning about proportionality.
And who falls into this legitimate interest category?
The law defines specific groups. It includes professional journalists based in the EU, certain nonprofit organizations focused on AML-CFT work, and this is quite significant potential counterparties to a transaction.
So if you're thinking of doing a deal with a company, you might qualify.
Potentially, yes. If you're considering a significant business transaction, you can apply for access to do your own checks, provided you can demonstrate that legitimate interest.
And how do you demonstrate it? Is it automatic?
No, definitely not. You have to submit a formal, motivated request to the LBR. You explain why you need the information, what your legitimate interest is. The LBR assesses these requests. They actually have an advisory committee to help, especially for those potential business counterparty requests.
And if they approve it, what information do you get? Everything.
No, it's limited. Access is restricted to specific details. The UBO's full name, their nationality, full date and place of birth, country of residence, and the nature and extent of their beneficial interests. It's curated access, designed to be necessary but not excessive.
Okay, that makes sense. It balances transparency with privacy.
That's the goal.
So, shifting gears slightly, we know who can get the information. But how do companies figure out who their UBOs actually are in the first place? You said it's complex.
It really is. It's not just ticking a box. The original law of January 13th, 2019, and importantly, guidance from the CSSF lay out a very specific three-step process. It's a cascade.
A cascade, meaning?
Meaning you must complete step 1 fully. If, and only if, that doesn't definitively identify the UBO, you move to step 2. And only if step 2 is inconclusive do you go to step 3. Each step has to be exhausted and documented.
Okay, let's walk through it. Step 1.
Step 1 is the ownership interest test. This is mostly quantitative. You're looking for any natural person who ultimately owns or controls more than 25% of the shares, voting rights, or ownership interest.
Directly or indirectly?
Both. You have to do a look-through analysis going up the chain of any intermediate companies until you find the actual person at the top. And crucially, you also have to consider if people are acting in concert. If individuals coordinate their influence, their stakes are added together for this test.
Right. So what if nobody hits that 25% threshold, or it's unclear?
Then you must move to step 2, the control via other means test. This is more qualitative. It's about looking beyond share percentages to how control is actually exercised.
Okay, you give some examples.
Sure. Does someone have the power to appoint or remove most of the board members or senior managers? Do they have dominant influence because of a contract or the company's articles? Maybe they significantly influence other beneficial owners or hold absolute decision or veto rights, even if their shareholding is below 25%. This step requires really digging into governance documents, shareholder agreements, things like that.
So it's about practical control, not just ownership percentage.
Exactly. It's a deeper analysis.
And if even that doesn't identify a UBO?
Only then, as a genuine last resort, do you move to step 3, the senior managing official SMO fallback. If you've exhausted steps 1 and 2, documented everything thoroughly, and still can't identify a UBO, then the person or people holding the senior managing official role, the dirigent principle, are identified as the beneficial owners for the purposes of the RBE.
But it really is a fallback.
Absolutely. You cannot just jump to identifying the CEO because it's easier. You have to show you've done the work on steps 1 and 2 first.
This really underlines something you mentioned earlier.
That it's a legal analysis.
Yes. Especially step 2, the control test. It's not just filling in a form. It's interpreting legal documents, understanding power dynamics. It sounds like getting expert legal advice early on is pretty crucial.
It's highly advisable. Performing that analysis correctly, building the compliant file, that's the high-value part. The administrative filing that follows is more straightforward, but it relies entirely on getting the analysis right first.
Okay, so let's assume the analysis is done, the UBOs are identified. What's next? The filing itself. What specific information is needed?
You need quite a bit of detail for each UBO. Their full name, all four names, nationality or nationalities, complete date and place of birth, country of residence, and a precise address, private or professional, plus their Luxembourg national ID number, the matricule, if they have one, if not, a foreign ID number. And importantly, a clear description of the nature and extent of their beneficial interests, how they qualify as a UBO.
And do you need to provide documents to back this up?
The main one is usually a copy of an official ID, like a passport, but only if the beneficial owner doesn't have a Luxembourg matricule.
How does the filing actually happen? Is it paper-based?
No, it's all electronic now. Everything goes through the LBR's online portal. The person doing the filing could be someone from the company, their lawyer. A notary needs a LexTrust certificate to log in and authenticate themselves. Then you basically fill out an online form, upload any required documents, and submit.
And the deadlines, you mentioned they're strict.
Very strict. For a brand new company, the initial filing must be done within 1 month of its registration with the Trade and Companies Register, the RCS.
And for changes, if a UBO changes, for instance.
Same time frame. Any change to the information held in the RBE must be filed within 1 month of the company becoming aware of that change. It's an ongoing obligation.
And the LBR processes these quickly.
Yes. They aim to process filings and issue a confirmation within 3 working days. If something's missing or incorrect, they'll let the filer know and give them 15 days to fix it.
Okay, let's zoom out a bit to the strategic side. What are the costs involved? And crucially, what happens if you get it wrong or miss those deadlines?
Well, the standard administrative fees for filing aren't huge. €15 plus VAT for an initial filing, €5 for an electronic extract. A request to limit access costs €200. The real financial sting comes from the new penalties for late filing.
The ones introduced recently.
Exactly. The Grand Ducal Regulation of March 13th, 2025, which took effect March 24th, brought in escalating surcharges. If you file in the second month after the deadline, it's a €50 surcharge. Between the third and fourth months, it jumps to €200, and from the fifth month onwards, it's €500.
Wow, that adds up quickly.
It certainly does. It makes that 1-month deadline a really critical operational target. It's clearly designed to push companies towards timely compliance.
And are there more serious penalties beyond those surcharges?
Oh, yes. The underlying law, the 2019 law, has criminal penalties. Failure to file or knowingly filing false or incomplete information can lead to a criminal fine. And the range is significant, from €1,250 all the way up to €1.25 million.
€1.25 million. That's serious.
It is. And it's important to note that liability isn't just on the company. It can also extend to the beneficial owners themselves if they fail to provide the company with the information it needs. It's a dual liability setup.
That really raises the stakes. You also touched on negotiation being relevant here in a broader sense. What did you mean by that?
Well, it's not just about arguing with regulators, although that can happen. I see negotiation happening in several areas. First, there's often internal negotiation. Think about a complex fund structure. Figuring out who the UBO is might involve interpreting complex partnership agreements, side letters. It can require careful discussions with general partners, limited partners, various stakeholders to agree on the correct analysis and get the needed info. That's a form of negotiation.
Okay, internal alignment. What else?
Then there's transactional negotiation. When companies are doing deals, M&A, financing rounds, UBO information is key for due diligence. With this new legitimate interest access, counterparties will be even more focused on getting assurances about RBE filings. So you'll negotiate specific clauses, representations, and warranties in the deal documents related to BO compliance.
Right, managing risk in transactions.
Precisely. And finally, yes, there's dispute resolution. If a regulator like the CSSF or even the public prosecutor challenges your RBE filing, you definitely need expert negotiation skills. Presenting your documented analysis, explaining your reasoning, negotiating a resolution, that's critical to avoid things escalating from an administrative issue to potentially a criminal one.
It sounds like the legal advice spans analysis, process, and potential disputes. How does that affect pricing for these kinds of services? Is it standardized?
Not really, no. It's quite nuanced. Pricing reflects the complexity and the risk involved. Several factors play a role. First, structural complexity. Analyzing a simple holding company is different from untangling a multi-layered cross-border private equity fund.
Naturally.
Second, the risk profile. Is the entity involved with politically exposed persons, PEPs? Does it operate in high-risk sectors or countries? That requires more scrutiny. And third, the scope of the mandate. Is it a one-off analysis for a specific purpose, or are you providing ongoing monitoring and advice?
So what kind of pricing models do you see?
You see a mix. Fixed fees might work for straightforward, well-defined tasks. Hourly rates are common for more complex advisory work, especially where the time needed for analysis is unpredictable. And you also see value-based retainers, where clients essentially outsource ongoing compliance monitoring and strategic advice to their legal counsel, paying for the expertise and risk mitigation provided over time.
Looking ahead now, this area seems constantly evolving. What's next on the horizon, particularly from a European perspective?
Europe is definitely pushing forward. The next big thing is the EU's comprehensive AML package. This includes the 6th Anti-Money Laundering Directive, AMLD6, and a new anti-money laundering regulation, the AMLR, which will be directly applicable in all member states.
Directly applicable, so less room for national variation.
Exactly. The AMLR aims for greater harmonization. And a key part of this package is the new Anti-Money Laundering Authority, AMLA. It's expected to be up and running by mid-2025.
And what will AMLA do?
It's going to directly supervise some of the largest, riskiest cross-border financial firms. But perhaps more importantly for everyone else, it will coordinate national supervisors and work to ensure rules are applied consistently across the EU. It signals a move towards more integration and potentially stricter, more harmonized supervision.
So, with that trend towards harmonization, how does Luxembourg's current BO regime position it? Does it have a unique advantage?
I think it does, increasingly so. Luxembourg's advantage now is offering a BO framework that is mature, sophisticated, and crucially, legally certain. It's been tested by the highest EU court, it adapted quickly and precisely. It offers predictability. In a world moving towards stricter, more harmonized rules, having a system that's already aligned with fundamental rights and proven to be adaptable is a significant plus.
So being an early and correct adopter of the CJEU standard is now a selling point.
I believe so. It provides stability for the international capital markets that rely on Luxembourg. It shows a commitment to the rule of law that sophisticated investors value highly.
It sounds like Luxembourg has found a kind of Goldilocks spot. Not too loose on transparency, but not overly intrusive on privacy either, and all within a legally robust framework.
That's a good way to put it. It offers that synthesis. Strong compliance with transparency goals, but done in a way that respects fundamental rights. That balance is precisely what demanding institutional investors and fund managers look for. It turns potential regulatory friction into a competitive edge.
Well, we've certainly covered a lot of ground. Hopefully you listening have had some of those aha moments about how Luxembourg's BO landscape has shifted. Let's just quickly recap the main takeaways.
Good idea.
First, RBE access isn't public anymore. The law of January 23, 2025 brought in that controlled legitimate interest system following the CJEU ruling. That's a fundamental change. Second, those deadlines matter financially now. The escalating late filing fees introduced in March 2025 mean that 1-month window for updates is a serious operational target. Procrastination costs real money.
A significant incentive for promptness.
And third, identifying the UBO is confirmed as a proper legal analysis, not just admin. That 3-step cascade requires careful judgment, especially the control via other means test. You have to look beyond the share register.
Absolutely. It requires diligence and often expert interpretation.
So as we wrap up, maybe a final thought for our listeners to consider.
Well, I'd say this. In today's complex financial world, mastering this balance between transparency and privacy, which Luxembourg's regime exemplifies, isn't just about ticking compliance boxes. It's actually core strategic risk management. It's about future-proofing your operations. So the question to ponder is, how will these evolving standards, this drive for purposeful transparency, shape your next strategic move?
A great point to reflect on. Understanding these nuances is key to navigating successfully. This podcast uses AI-generated content. All information is for general purposes only and does not constitute financial, investment, legal, or regulatory advice. Listeners should verify information independently and consult qualified professionals for personalized guidance. Hit that like and subscribe button. It was the Luxembourg Fundcast for you today.